What's up, everybody? We are back on the Kohberger train here to discuss the judge's decision on the gag order and on the question of whether or not we will have cameras in the courtroom in this case, and also his decision to take judicial notice of the media attention in this case, which seems very obvious, but nonetheless, we will go through that order as well. Thank you for joining me. We've recorded all of these Kohberger things at kind of random times, some of them live, some of them recorded. I wanted to make sure I got through all these documents and was able to get them out to you as quickly and efficiently as possible. So that is why we are recording this today for you at the house with, as my son calls it, my Thor hair and the new Lawyer You Know 4th of July merch, which is pretty cool. This shirt is a medium, is definitely too small, but in like the samples that we all got, we did not get a large. A large would definitely be my preferred size for anybody wondering how they fit. I think they run a little small, if anything, but hit that like button if you haven't already. Subscribe to our page. Let's get to what the court said about all the media attention on this Kohberger case. Some of it is pretty similar to each other. We're going to run through it, starting with, like I said, the court taking judicial notice of the media attention in this case. Order granting the motion to take judicial notice of press coverage. On May 1st, 2023, a coalition of 20 media outlets filed a motion to intervene and a motion to vacate the amended non-dissemination order. In opposition to the motion to vacate and amended non-dissemination order, defendant Brian Kohberger filed a motion to take judicial notice of the press coverage. So what this means is that there is press coverage. Legally speaking, the court has decided there is, in fact, press coverage in this case. Ta-da! Ooh, what a big deal. Oral argument was heard. The state was represented by Thompson and Rudley. Prosecutor's office. Defendant was represented by Taylor and Logsdon of the Kootenai County Public Defender's Office. The Associated Press was represented by Wendy Olson and Corey Carone. For the reasons articulated on the record, the defendant's motion to take judicial notice of press coverage is granted. And that's it. Simple as can be, right? But other things happened. So let's jump right to the judge's order denying Shannon Gray's request to be exempt from the non-dissemination order. This was a 27-page order. We're not going to read through the factual background again or the law again. We've heard that. We've read that. But what we want to stick to is what is the court's analysis. So that's what we're going to look at here. The court's analysis to Shannon Gray's request and why he said no to Shannon Gray, and that Shannon Gray is still under the non-dissemination order. We're later going to read the revised non-dissemination order, and hopefully I remember to put it in the context of Shannon Gray saying, nobody deserves the death penalty like this defendant. Anytime he makes a public statement now, in the beginning, if he was reading this and not sure whether he's covered under it because it's too vague, he would have at least had plausible deniability. But now, because he's gone before the court, he's asked these questions, the court has given this order denying his request to be exempt. Now he's towing the line every time he says something publicly. So the analysis starts with this court has an obligation to take measures to ensure Kohberger's right to a fair trial, including prescribing potentially prejudicial extrajudicial statements by any lawyer participating in the case. Few, if any, interests under the Constitution are more fundamental than a right to a fair trial by an impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. This court also recognizes the fundamental right to free speech. Sorry, I was just checking to make sure the right mic was picking up because I've had that issue lately. To free speech under the First Amendment. However, with the advent of the internet and social media, the tensions between the First Amendment and Sixth Amendment continue to increase, as was outlined in Shepard. The trial courts must take strong measures to ensure that the balance is never weighed against the accused. So just FYI, that's a little wink, wink, and hint to where we're going. The more internet, media attention, social media that these cases get, it seems like the more risk there is of a defendant's right to a fair trial being taken from him or trampled on. So we have to make sure we do not do that as people that talk about this in the public and on social media. Let's not be a reason that this becomes an unfair trial for an accused. And the more we do that, the more we will be able to take part in and watch and listen to and learn from the judicial system. This is not the Colosseum in Rome. We should not want to and enjoy watching people burn. We should not want to see people going at each other, a fight to the death for sport. That is not what this should be. This should be educational, us learning the system and us calling out injustice in the system, because we, the people, are supposed to rule this country as a democracy. And if we disagree with things that are happening, our vote, our money, our time can make a difference. That's what this is supposed to be, with the internet and publicity and public and media following a case. We should not be making decisions in these cases when we first hear that there's an arrest, or we watch a hearing, or we read a document. That should not be our time to make a decision and say, whoop, he's guilty. Let's do everything we can as the public to pressure anyone that could possibly be on that jury to make sure this guy's guilty, because we know it sitting in Clearwater, Florida, about this Idaho case. There's a reason I could never sit on this jury. I don't live where I need to live in the community I would need to live in order to even be eligible to be a juror on this case. So I should not be making this decision. And the more we can remember that and implement that into our everyday life, into our social media life, and what we post out there and talk about. Now, to discuss it, state seems like they have a lot of evidence. If he is the guy, death penalty might make sense. Or I don't agree with the death penalty. Even if he is the guy with these aggravating factors, I wish there was no death penalty. Those discussions are fine. We need to make sure that we're using social media appropriately too, because all of these orders are pointing towards a direction of, yeah, First Amendment, but because of the big bad internet, let's just shut everything down and handle this inside of a courtroom, because what is more important than the First Amendment is a right to a fair trial. And I do agree with the judges in that estimation, or decision, I should say. In this case, the amended non-dissemination order in place by the party stipulation to protect Kohberger's right to a fair trial is aimed at attorneys participating in the case and their agents. The U.S. Supreme Court has made clear that a trial court can prescribe extrajudicial statements by any lawyer, party, witness, or court official which divulge prejudicial matters. Neither prosecutors, counsels for defense, the accused, witnesses, court staff, nor enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censorable and worthy of disciplinary measures. By regulating and restraining the speech of trial participants, the court can help to ensure a trial free from outside influence without corresponding curtailment of the news media. As was stated by the Ninth Circuit in Levine, the case for restraints on trial participants is especially strong with respect to attorneys. The speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than strict scrutiny, because lawyers involved in a case are key participants in the criminal justice system, and the state may demand some adherence to the precepts of that system in regulating their speech as well as their conduct. I got to be honest, this is a really well thought out and well written order. It makes a lot of sense. And he's determining, how he has to look at this. He said it was not strict scrutiny, and he explains why. And he also explains how when you're a lawyer who represents somebody involved in this case with more information than I would have, that's why it's different. We're sitting here talking about like, hey, I'm telling you, and I tell you this in every case, we do not know everything. Because I'm a real lawyer handling real cases, I know what lawyers know on cases that they handle. And it is very different what I know on those cases and what I know on this case. Now, I can surmise and talk about and guess what they're arguing, why they're making this, where their leverage is, what arguments they can make against certain evidence or with experts, and we can talk about that. But if you're not the lawyer handling the case or representing a witness or a law enforcement agency even, or the press even, she's more involved now in this case and knows more about this case. As she mentioned, death penalty notice is coming, and then boom, there it was. It's very different when you're a lawyer actually involved in the case or a lawyer just talking about a case. As was discussed in detail above, the rationale for allowing an attorney's speech to be more regulated than speech by a non-attorney is, 1, a lawyer's status as an officer of the legal system and a public citizen having special responsibility for the quality of justice. 2, lawyers participating in the case have special access to confidential information through discovery and client communications. And 3, statements are likely to be received as especially authoritative. Again, we already know that there are bar rules and restrictions placed over lawyers and bodies that can reprimand and sanction lawyers. The judge, obviously, in this case, did not feel like that was enough to restrict what they say, and that those were too lenient, basically, is what I'm gathering from this. And so the judge said, for this specific case, I need to restrict you even more than the bar rules do and the rules of ethics do. Rule 3.6 of the Idaho Rules of Professional Conduct set forth the specific requirements, restrictions for lawyers participating in a case when it comes to trial publicity. The purpose of the rule is to guard against materially prejudicial extrajudicial statements by attorneys participating in a case that might impair the right to a fair trial. So obviously he thinks that's a risk here. Similar, the ABA has promulgated a standard for lawyers participating in criminal matter that restricts extrajudicial statements that, one, have a substantial likelihood of influencing or prejudicing the outcome of a trial or jury, and two, that heighten public condemnation of a defendant, a witness, or a victim, or three, that undermine the public's respect for the judicial process. Taken together, the case law and the standards governing attorneys make clear that, one, the court has an obligation to take measures to ensure that the balance between the First Amendment and the Sixth Amendment is not weighed against Kohberger, and two, the court has authority to impose restrictions on the speech of attorneys participating in the case when it comes to extrajudicial statements that have a substantial likelihood of materially prejudicing potential jurors or a fair trial. So again, we have been through all that. We're going to skip through where he says strict scrutiny and a less demanding standard have both been applied to restrictions on lawyer speech. The court in this case decided to apply a less demanding standard. Number three, the case law and ethical rules support a finding that Gray's speech can be restrained without violating the First Amendment. This court's revised amended non-dissemination order will narrow and clarify that speech. Let me try this again. This court's revised amended non-dissemination order will narrow and clarify what speech is restrained and what speech is not restrained to withstand strict scrutiny. Also, it says this court's revised amended order. Revised. Gosh. This court's revised amended non-dissemination order. So, sorry, let me just go back to this because what I said may have been confusing. The court said they do not have to apply strict scrutiny, but the court's end-up answer is what I do, my non-dissemination order will meet the higher standard of strict scrutiny. So he wanted to make sure that everybody knows he does not have to, his decision is he does not have to apply strict scrutiny, which is what the media told him he had to apply. So he wanted to make that clear while also saying what I do will meet the higher standard. Okay? Just want to make sure that was clear. That's why skipping over parts and trying to move quickly through it, sometimes you can miss stuff. So while only the occasional case presents a danger of prejudice from pretrial publicity, this case, as recognized by the Idaho Supreme Court, has drawn widespread publicity, garnering worldwide media attention and much speculation. And therefore, pretrial publicity does present a real danger of prejudice. It's important to differentiate this case and just every case that we could do non-dissemination orders if it could poison the jury pool or affect the verdict. Recognizing the high-profile nature of the case and the extensive coverage it has received, along with the need to minimize possible pretrial prejudice, the parties stipulated the entry of an original non-dissemination order and the amended non-dissemination order. As was noted by the District Court Stephen Boyce in his memorandum and decision and order prohibiting video and photographic coverage in the case of, what case did we say would be referenced? What case did we say we were going to learn so much about this case? What case did we say pointed exactly to where I feel like this case is going if we're not careful? The state of Idaho v. Lori Noreen Vallow, a.k.a. Lori Noreen Vallow Daybell. Agreement between the state and defense on any issue in a capital case is rare, further confirming to the court the legitimacy and level of concern counsel have raised. The same issue is true in this instance. We knew that was going to be a case they looked at and likely followed because judges like to agree with other judges. We've said that before. As was presented at the hearing on June 9th, the parties have a legitimate concern for information being disseminated to the media by attorneys involved in the case, including attorneys representing the families of the victims and attorneys representing witnesses. While these attorneys and their clients are not parties to the case, they are undoubtedly participating in the case. Because the victims' families are themselves victims in the case, and are also potential witnesses, they are in a unique position and have a right to obtain information not available to the public, as noted by the court in Gentile. Because lawyers have special access to information through discovery and client communications. Okay, we've read that 3 times now. Here we go. As defense counsel stated during oral argument, when Mr. Gray speaks, people listen. It matters to have counsel abide by the ethical rules. So this is like a little backhanded compliment. It's like when you speak, people listen. You've got a big voice. You're really important. People think you're legit. And because of that, you're part of the non-dissemination order. Additionally, because Gray has initiated a tort claim against the city of Moscow, law enforcement, and the University of Idaho on behalf of the Gonsalves and Mogan families, he may also have special access to information through discovery that, again, is not open to the public. Now they're conflating issues a little bit because that civil case is a different case than this criminal case. Different rules. Nobody agreed to a non-dissemination order in that civil case, especially not the parties if they're the parties. So this is a little bit of a gray area in the sticky situation that I probably wouldn't have even mentioned. I think the court's order was fine without this. This access to confidential information, coupled with the advent of the internet and social media over the past several decades, makes this court's task of balancing Gray's First Amendment rights with Kohberger's Sixth Amendment right an even more difficult task than it was for the courts in Shepherd, Nebraska, Levine, and Gentile, but not than Lori Vallow, because that just happened. But the facts of this case and the circumstances presented to the court during oral argument make it clear the obligation of the court to ensure all attorneys participating in the case are, at the least, abiding by the ethical rules that restrain comments to the media and public about certain aspects of this case. This, in my opinion, was the worst paragraph in the order, because if he's saying that there's already rules in place of ethics, then why do we need the non-dissemination order? Why not just reprimand attorneys if they break the rules of ethics? Number one. Number two, I didn't love the whole discussion about the tort claim. Also because it's actually less likely either side is sharing any information with them if they're now basically adverse to both people. Obviously adverse to the defendant in the case that they believe did this, and obviously adverse now to the state if you think they're suing them. So how are they going to get information as part of the criminal case? I don't know. That's the only part I took some issue with so far. This is a high-profile case, substantial media attention. We know that. The stakes are high. Kohberger, who's potentially facing the death penalty if found guilty, now we know he is. Given this backdrop, the court must take measures to ensure his fair trial. Gray, through his clients and the other attorneys participating in the case, have special access to confidential information. We know that. He's issued statements and participated in television interviews that the parties view as a violation of the current amended non-dissemination order. We will see if the new non-dissemination order, which I haven't read yet, if it tells him he can't go on any news stations and can't even sit there while his client talks. Gray did not dispute these representations. I don't think he agreed that he violated the non-dissemination order. Maybe potentially. Extrajudicial statements by lawyers involved in a case pose a threat to the families of a pending proceeding, since lawyer statements are likely to be received as especially authoritative. By the way, if Gray agreed and then he still came out and made the statements about the death penalty, about how nobody deserves it more than this defendant, based on the circumstances of the case and the facts, this court finds that extrajudicial statements by lawyers participating in the case that have a substantial likelihood of materially prejudicing a fair trial or sentencing pose a clear and present danger or a serious and imminent threat to Kohberger's fundamental right to a fair trial by an impartial jury. Further, this court finds that there are not less restrictive alternatives available to prevent prejudicial information from being leaked to the media by lawyers, like the rules of ethics. As noted in Gentile, while change of venue, delay of trial, or sequestering a jury may be tactics to help filter out the effects of pretrial publicity, the state has a substantial interest in preventing officers of the court, such as lawyers, from imposing such costs in the judicial system and on the litigants and on the jurors. Sequestering a jury, to me, is a much, much, much worse and more restrictive alternative than a non-dissemination order. A non-dissemination order aimed at attorneys and their agents privy to confidential information is the best prophylactic measure to ensure a fair trial, while other measures may be necessary down the road, requiring Gray and any attorney involved in the case to comply with IRPC 3.6 as echoed in the court's revised amended non-dissemination order is a reasonable action at this time. I mean, he's really, to me, saying, I don't think you guys are following the rules of ethics. Finally, while the current amendment on dissemination order is arguably overbroad and vague in some areas, hey, he kind of agrees with it. We heard from the Supreme Court that they might have an issue with it. This court's revised order. So he is writing an order he thinks fixes these issues. It is going to be narrowly drawn to prohibit only extrajudicial statements that have a substantial likelihood of materially prejudicing this case. The revised amendment on dissemination order includes specific examples of what speech is prohibited and what speech is allowed. The restriction on attorney speech applies equally to all attorneys participating in the pending case and will restrict the attorney's comments only until after the trial and any sentencing proceedings. The regulation of Gray's speech and the speech of all attorneys involved in the case is again narrowly drawn and necessary to protect Kohberger's right to a fair trial. Conclusion, Gray's request to be exempted from the non-dissemination order is denied. However, Gray's request that the amended non-dissemination order be clarified is granted. So we are going to get some clarification. I don't think Shannon Gray is going to like it. Gray, as an attorney participating in this case by representing a victim's family who are also potential witnesses, I guess he bought the state's arguments that they are potential witnesses. That I kind of felt like was unfair based on the state's actions so far in this case. Must comply with Rule 3.6 as echoed in the revised order. Okay, let's now get to the media, the analysis that the court had to the media's request to get rid of this non-dissemination order altogether, or at least amend it, which we know the court eventually did. We are going to skip the parts of the analysis that are exactly the same, which is this: only occasional cases present this issue. Quoting Judge Boyce again in the Vallow case, the court has to balance First Amendment and Sixth Amendment statements made by any lawyers. Yep. All this is the same. Strict scrutiny again. While the press does have a right of access or right to gather information with respect to criminal trials, the right is described only as a right to sit, listen, watch, and report. The media's desire to obtain access to certain sources of information that otherwise might be available is not sufficient interest to establish an infringement on freedom of the press in this case. As such, strict scrutiny does not apply. All right. Media coverage is ongoing. All right, here, I think this might be a little bit different. All right, the evidence presented by the defense shows that one, so this is the experts that the defense presented. The judge at least bought some of the argument. One, media coverage in this case is rampant and ongoing. Two, at least some, if not most, of the news coverage is prejudicial to Kohberger. Three, a portion, I like how the judge said that. At least some, if not most. He's not going to say all. He's not even going to say most. He said some, and if some is there, that may be enough. And if it's not some, it's probably most. I like the way he said that. Is negative or prejudicial to him. A portion of the statements being made to the media are coming from an attorney participating in the case, a la Sharon Gray. 4, vacating the non-dissemination order would increase the potential for bias among prospective jurors, both initially and throughout the trial. I don't necessarily disagree with how this case is being publicly discussed. I think there's absolutely a threat of prejudicing potential jurors. And 5, anti-defendant pretrial publicity increases the probability of guilty verdicts, and that this bias persists despite the receipt of trial arguments / evidence, admonitions to disregard the public information, and jury deliberation. So anybody that thinks lawyers are horrible scumbags that say, I don't know how any juror would be able to put this out of their mind, or it's hard if there's this much media attention for the juror to really ignore all of this. Well, the court is basically saying that is true. If we don't cut this off, it is going to be near impossible for any juror to get over the anti-defendant pretrial publicity because it increases the probability of guilty verdicts. And the bias persists despite the court telling them, admonishing them, disregard that. And regardless of the arguments made at trial and the evidence that the lawyers and parties present at trial. So this is the court recognizing sometimes, regardless of the legal barriers and protections we put in place, sometimes it's impossible for jurors to get over certain things that have been drilled into their head by the media and social media when they come to be a juror on a case. And that's what we want to protect against. And we got to start early sometimes. Commentary by individuals with status/expertise in the media coverage create more prejudice or more potential for biased jurors. To defendant's objection to the media's motion to vacate an amended non-dissemination order. I agree with the judge, but I also think there are people in the media that could push the presumption of innocence, push the burden of beyond a reasonable doubt, push people to wait. If you're a potential juror, wait until you get there and actually see what the real evidence is, not what everybody else is talking about and speculating, and TikTokers accusing Idaho professors of committing the crimes. Just wait until you get to trial. And if you want to know what's going on, you can watch the media and listen. This is what's happening. They're seeking the death penalty. There's a notice of this, notice of that. That's fine. Because you're just a human being at this point. You're not a juror. If you're a juror, you can't look at any of that stuff, obviously. But at this point, you're just a human being, and you may live in the community that can be picked for this jury. So if you're watching the news, nobody's going to condemn you for that. But you shouldn't watch the news and make up your mind that Brian Kohberger is guilty at this point. As currently drafted, the non-dissemination order is arguably overbroad. Okay, we read this. The court's going to revise it. We read this. Restriction on attorney speech. All right, conclusion. As to the media's right before the conclusion, as to the media's constitutional challenge, the restrictions imposed on attorneys participating in the case and their agents are not only reasonable and legitimate considering the high-profile nature of this case, but also meet the strict scrutiny standard. So he's saying, while I don't need to meet strict scrutiny, I am. The Associated Press's request that the non-dissemination order be vacated is denied. However, we will replace it and clarify it. So let's get to that clarification. The revised non-dissemination order revised amended as discussed in detail in this court's order denying Shannon Gray's request and denying the Associated Press's request. The court must attempt to balance the Sixth Amendment right to a fair trial and the First Amendment right to free speech and press. To preserve the right of a fair trial, some curtailment of the dissemination of the information in this case is necessary and authorized under law. Therefore, the following is ordered. The prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family are prohibited. And any attorneys representing witnesses, victims, or a victim's family are prohibited from making extrajudicial statements, written or oral. So they cannot do it if the statement so what is it? What statements can they not make? That the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of a case. What's funny is people ask a lot of times, why the language of knows or reasonably should know? Why is that language so often in legal documents and in elements of cases? The reason is people can stand up and lie and say, I didn't know. It's like, fine, you didn't know, but should you have known? Should you have known? A lot of that came up in the Scott Peterson case and a lot of other trials. Knew or should have known is really important because that gets around if somebody's going to lie and say, I didn't know, because you can provide facts that they reasonably should have known. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. So if you're telling a media company, obviously you know they're going to kick it out there for everybody to see. But you cannot do it if you think it's going to materially prejudice or influence the outcome of the case. And specifically, some things that you cannot talk about. The identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. That one I love. Always. Wish the media would do that. The character, credibility, reputation, or criminal record of a party, victim, or witness. The identity of a witness. A lot of this is the same, by the way, but we're still going to go over it. The expected testimony of a party, victim, or witness. The performance or results of any examination or test, or the refusal or failure of the defendant or a witness to submit to an examination or test. Again, this does not include the motions that are filed back and forth from the defense and the state. Some of them are under seal if they need to be, or a protective order of some sort. Any opinion as to the guilt or innocence of the defendant. And when Shannon Gray made that statement after this non-dissemination order, after the notice of intent to seek death penalty, that nobody deserves it as much as this defendant. I'll see if I can pull up the exact quote here. All right, we made a quick cut there because I had to go look for this Shannon Gray quote, and I found one even better because as judges like when people agree with them, I like when good lawyers agree with me as well. And our friend Andrea Burkhart here on Twitter, I'm going to share her tweet. Can you see that? So Andrea Burkhart literally highlights where we're at. So the quote Shannon Gray made, there is no more deserving than the defendant in this case about the death penalty, when asked about the death penalty. And she highlights exactly where we are. Any opinion as to the guilt or innocence of the defendant. Okay, so here's kind of more of the quote from Morgan Romero. The Gonsalves family is grateful that the prosecutor's office is pursuing the death penalty. There is no one more deserving than the defendant in this case. We will continue to pray for all the victims' families. That's the quote I read. So Andrea kind of summarized it, but that statement to me, he is only deserving of the death penalty if he committed the crimes, right? We all agree with that. So that to me feels like a statement about innocence or guilt. We'll see what the judge says. We'll see if anybody objects to that. I feel like if I was the defense attorney, I would probably bring this up to the judge and say, Judge, this is exactly why we need it. And I think you need to remind Shannon Gray. I don't think he's going to get, sanctioned or anything like that, but maybe a stern reminder to Shannon Gray not to make any statements that have an opinion on the guilt or innocence of the defendant. All right. What else? The possibility of a plea of guilty to the offenses or any comment on any plea discussions, the existence or contents of any confession, admission, or statement by the defendant, or a refusal of the defendant to make any statement, any information obtained by witnesses, the victims' families, or their attorneys from the state that is confidential and has not been publicly disclosed by the prosecuting attorney. So if the state tells you anything, Shannon Gray, or if the state tells any of the victims anything, you cannot say it publicly unless the state attorney has first. Now, one of the problems is that is confidential. Can they say, I didn't know it was confidential? He could have just left that out and just said any statement the state makes to the victims unless the state publicly discloses it first. Or is that supposed to define confidential? Everything's confidential unless the state publicizes it first. Attorneys involved in the case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following: the claim, offense, or defense involved, and, except when prohibited by law, the identity of the parties involved, information contained in the public record, that an investigation is ongoing, the scheduling or result of any step in the litigation, a request for assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case, a warning of danger concerning the behavior of a person involved. Interesting. Oh, danger to a person involved. I was going to say like the danger of Kohberger or his family or something. When there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest, the identity, residence, occupation, and family status of the accused. Interesting that they're allowed to talk about that. The fact, time, and place of arrest, the identity of investigating and arresting officers or agencies, and the length of the investigation, and a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. So you can respond if you need to, but again, not say anything that we mentioned above. But this is interesting, some of this stuff, because lawyers can get creative on what they say falls into one of these categories. And maybe he'll say the death penalty is now something that's contained in the public record, so he's allowed to comment on it, and that he agrees with the state. And that's it. The state obviously thinks Kohberger deserves the death penalty, so he's just agreeing with the state. He said nothing about guilt or innocence. I think there are some things you could kind of try to fold this into. No individual covered by this revised amended non-dissemination order shall deliberately avoid its prescriptions by actions directly or indirectly that result in violating this order. So Greg could say it was an accident. Obviously, I think it was an accident. I don't think he intentionally violated it, if in fact he did violate it. I think he can make some arguments it fits into some of those other ones. This revised amended non-dissemination order shall remain in full force and effect until the conclusion of a trial and any sentencing proceedings that may follow unless otherwise ordered by this court. So this is what's going to stay in place. So lastly here, and we're going to bring up the Vallow case again, because this is the court's order and decision on cameras in the courtroom. Order reserving ruling on the issue of cameras in the courtroom. On May 1st, a coalition of 20 media outlets filed these motions. They were allowed to be heard. And here's the judge's decision. Given the high-profile nature of this case, the public's interests in watching what is happening in the courtroom, and Kohberger's fundamental right to a fair trial by an impartial jury, the court will reserve ruling on the issue of cameras in the courtroom. What does that mean? He didn't make a decision. Reserving ruling in a situation like this means continuing the status quo of what's happening right now. So by not making a decision, he's allowing cameras in the courtroom for now, which again is where we come into play. How do we talk about this case? How do we use cameras in the courtroom? Do we use it to try to convince everybody in the public that Bryan Kohberger is guilty or innocent? Or do we use it to learn and understand how this process works, how it's going, making sure things are done the right way by lawyers, judges, law enforcement officers as much as we can? How are we going to use it? Because that can have a direct effect on the judge's decision in the future. Again, just like it did in another Idaho case that this court has already referenced. Vallow had cameras for a long time. Judge Boyce felt they pushed it too far with the makeup and zooming in on her face and making all these descriptions about how she looks and what she's doing. They're out. Same could happen here. He's reserving ruling. The court is faced with the difficult task of ensuring the proceedings are open to the public while also safeguarding Kohberger's right to a fair trial. The best way to continue to balance those interests is to revisit the issue of cameras in the courtroom as the case unfolds. This court has the discretion to either allow or disallow video recordings of the proceedings. That's true. We saw it in Vallow. For now, cameras in the courtroom will continue to be allowed. However, that is subject to change by further order of this court. So he does reserve the right to change his mind, especially if new information or evidence is presented to him to show that cameras are now adding to the prejudice. They're adding to poisoning of the potential jury pool here. So our actions could directly affect this as the public, as people watching this from afar or even near. So let's make sure we keep that in mind. If it's something that we want to watch and learn about and think that watching it is important, which I do, covering a trial that you can just listen to versus one that you can watch is completely different. And understanding what's happening in the actual trial. So a lot happened there. And what I want to know in the comments from you is, do you agree with the judge's decision to deny Gray and the media's motion? What do you think about the non-dissemination order, the amended one written by this court, putting his own stamp on it, not taking another judge's non-dissemination order, which he said is arguably too vague? What do you think about it? And how are you going to act now, knowing that cameras in the courtroom is going to be directly affected by how we and the media, the ones with the cameras in the courtroom, how we all act, how we use the information that we're getting publicly as the public? Let me know your thoughts. Let me know your questions. I appreciate everybody joining me. Hit that like button on the way out. Until next time, thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.